Okay, so I think we're now live on Facebook. Thank you everyone for your patience, and thank you so much for coming and joining us here today. My name is Stav Salpeter and I'm the Director of Community Engagement at Yachad, and I'm very pleased to be hosting this webinar on this very eventful day together with Defend Israeli Democracy UK, which is the Israeli pro-democracy protest movement in Britain. And we're delighted to be hosting the Association for Civil Rights in Israel today to focus on the petition that was heard in Israel's High Court of Justice today against the first step of this government's so-called judicial overhaul. If you're new to Yachad, if this is one of your first events with us, we're a British Jewish organization that mobilizes the community in support of a resolution to the Palestinian-Israeli conflict. And we do that, first of all, in work within the British Jewish community, in organizations like the Board of Deputies and with other representative communal bodies, such as the Jewish Leadership Council. We do it together with youth movements across the religious spectrum and synagogues across the country. We also do that by representing the views of our supporters in Parliament and advocating for our values. And throughout our work, one of the things that we prioritize is platforming the voices of our Palestinian and Israeli partners on the ground, because they're the ones who are, at the end of the day, working day in and day out in order to bring about peace and bring about an end to the occupation. And that's why I'm really pleased that we're hosting this webinar series. Every 2 months, we focus on a topical issue in Israel-Palestine and take a step beyond the headlines with a briefing from one of our partners on the ground. So in the past, we've hosted a webinar with Iramim about settlement expansion in East Jerusalem in the context of the racist flag parades that take place in the city every year. We hosted a webinar with Physicians for Human Rights in Israel about the impact of the blockade on Gaza on Palestinian women living there. And I'm really happy that we have the Association for Civil Rights in Israel with us today. ACRI is the oldest civil and human rights organization in Israel, founded in 1972, and it's the only NGO in Israel that advocates across the broad spectrum of human rights and civil liberties for everyone living in Israel and in the Occupied Palestinian Territories. And the reason that we invited them today is that they have led a historic petition on behalf of 38 Israeli human rights organizations to the High Court of Justice. This petition is against the government's cancellation of the Reasonableness Clause and focuses on the threats that this law poses to minoritized communities, to women, to the LGBTQ+ community, and to Palestinians in the occupied Palestinian territories. But before I kind of pass on the baton to them, I'd like to introduce our co-host, Defend Israeli Democracy UK, and the leading activist who we have from them with us today, Dr. Sharon Shochat. Sharon is a political scientist by training and a passionate political activist. She holds a PhD in government from LSE and a postdoc in public policy from Tel Aviv University. Alongside her academic teaching, she also has extensive political experience as a parliamentary assistant in the House of Lords and a writer for CNN. And she's one of the leading activists and a founding member of Defend Israeli Democracy UK, which has been staging the protests in London since March and this very successful Democracy Week last week. I can say on behalf of Yachad that it's really been a pleasure to, first of all, watch this movement led by Israeli expats here, a really, really wonderful grassroots movement growing over the past few months, and also take part of it alongside our other communal partners to make sure that, Israeli expats here and Israelis living at home know that the British Jewish community stands with them in their fight for democracy. But yes, I'll hand over to Sharon for a few words before we start our briefing today.
Thanks. So, hi, everyone. I thank you for the kind welcome words. I'm very pleased to be here today. It's a fundamental day in Israel today. I was watching the Supreme Court deliberations live, as it's all available and accessible in fascination and horror in equal measure. We are at the cusp of losing democracy in Israel. There's no way to exaggerate the processes that have been going on since this government took office in January, and since this judicial reform, which is actually an overhaul of the entire system of government in Israel, was announced in January 4th. Today we're discussing this particular Supreme Court deliberation on the abolishment of the Reasonableness Clause, but there's a body of legislation that includes 225 laws that are being in different stages of reading in the Knesset. Some have passed, some are waiting to be discussed, and together they are not only meant to make the judiciary less independent and remove checks and balances that are necessary in any democracy, but also to affect human rights, women's rights, minorities' rights, the freedom of the media, freedom of the press. I have various examples, but also to impose religious norms across society, to control the conduct around elections. So eviscerating the judiciary is a necessary step in the government's program to basically change Israel's core values, the liberal democratic values upon which this country was founded. And this is what we're fighting. This is what people are fighting in the streets in Israel, and this is what we're fighting here and in other cities around the world, to echo that struggle, to give Israelis who are protesting in the streets some resonance from abroad, so that they understand that there's support outside the borders, and also to send a very clear message that this is not an Israeli problem, not only an Israeli problem, this is a problem for the Jewish world, for anyone who is Jewish, for the Jewish diaspora, because what happens in Israel affects all of us, wherever we are, and we all have the responsibility, the legitimacy and the duty, not just the right, to speak up and do something about it. So pleased to be here, and handing over to Hagar.
Thanks very much, Sharon. I think before
me, Tamara,
Yeah, I'll also just give a brief introduction to Tamara and Hagar, but thank you for that, Sharon. I think that's really impactful. And I think, I know that you on a personal level and everyone at Defend Israeli Democracy have been working days and nights really to make the protest happen in the UK. And it's been really inspiring to see them take shape. So I'd now like to hand over to the Association for Civil Rights in Israel. And we're very pleased that we have not only one, but two speakers from them with us today. Tamara is going to speak first. Tamara Newman is ACRI's Director of International Relations. She was involved in establishing the New Israel Fund in Australia. And then when she moved to Israel in 2013, she's been working in the field of refugee rights. She was the Director of International Relations and Development at the Hotline for Refugees and Migrants, where she established and managed an emergency humanitarian aid program for the refugee community at the outbreak of Corona, and also worked at Elifelet, Citizens for Refugee Children. Tamara holds a BA in Development Studies and History from the University of New South Wales and a master's degree in Nonprofit Management from the University of Technology in Sydney. She will be followed by Hagar Shechter, who is an attorney in the Unit for Civil and Political Rights of ACRI's legal department. Hagar completed her LLB magna cum laude alongside the Amirim Honors Program for outstanding students, and also has an LLM from the University of Michigan as a Fulbright scholar. Hagar worked as a lawyer at Lustigman and Blank, specializing in human rights, where she focused on the status and immigration and represented residents of the Occupied Palestinian Territories in East Jerusalem, asylum seekers, victims of human trafficking, and migrants. We're very glad that the petition ended in such a time so that Hagar would be able to join us today and give us a bit more of an in-depth legal briefing as to what exactly happened in the High Court of Justice today. But before we go into that, Tamara will provide some wider context in the lead up to this case and tell us a little bit more about ACRI's role. Just in terms of housekeeping, before we start the briefing, Tamara and Hagar will give us their briefing for about half an hour, 20 minutes. and then we will open up the floor to questions. So if you're already having, some questions that you'd like to ask, you can do that already now, and I'll moderate questions for about 20 minutes after Hagar and Tamara speak. Please note that the chat is disabled, so if you'd like to ask a question, you could do that at the specific button that says Q&A at the bottom of your screen. There's a kind of chat-like bubble next to it. If you can't find it, then feel free to send me a personal message. But yes, I'm happy to pass on to Tamara now.
Great, thank you so much, Stav. Stav, if you can give me a thumbs up, if you can hear me, if everything's okay. Great, okay, I've got a thumbs up. Thank you so much for participating, and thank you to everyone who's joined tonight. It's really see how many people are here with us. I just need to make one correction. The case is still going. They are still in the High Court. They have been there since 9 a.m. this morning. At about an hour ago, we finished hearing from our wonderful colleague, Gil, who is leading ACRI's petition there today, and they've continued on. Even though over an hour ago, the judges definitely sounded like they were very ready to go home. They've been sitting there for more than 10 hours. So our colleague Gil, who's representing us there today, as he said, he's representing ACRI's case, which is on behalf of 38 human rights organizations who have come together in a coalition where ACRI is representing in a call to strike down this law based on the damage it will do to human rights, and more specifically, the damage it will do to our ability to protect human rights. So we are talking about every vulnerable population in Israel, whether that is Arab citizens of Israel, Palestinians in the occupied territories, migrants, Jews with Ethiopian origin, Russian speakers. It is about protecting the mechanism that we have in order to protect ourselves. So it's not just about who are the people who are vulnerable today, it's also about who the people who will be vulnerable tomorrow, because it's the system that we have in order to protect them. And so ACRI's case was submitted as an amicus curiae, as a Yedida Beit Mishpat, friend of the court. So we were there arguing as our, in our expertise as on human rights specifically, amongst another 8 petitioners and one other friend of the court who was also there, which is Adam Teva Vadin, colleagues in an environmental organization, about the damage it will also do to protecting the environment. But I'm going to step back a little bit and put today's case in context, because, and this was a huge part of the case this morning, you cannot talk about what's going on in Israel right now today just about the reasonability clause. It is about a bigger picture. And that picture started, I guess you could say, well, you could say many years ago, but I'm going to start from November 1st, where we had elections in Israel. And following those elections, there was established the most right-wing extremist government in the history of the state. The government is made up by a coalition of Likud, which is Bibi's party, most moderate of sorts in this coalition, religious Zionism, who carry banners of fascism and Jewish supremacy, and Shas and Yahadut Torah, which are the 2 ultra-Orthodox party, one that is generally the Mizrahi or Sephardi ultra-Orthodox party, and Yahadut Torah, United Torah Judaism, the Ashkenazi ultra-Orthodox, who carry with them a very misogynistic, patriarchal worldview. And they have come together. They're not a match made in heaven. If you're following the news, you'll also see that the big tear in the last few days isn't around reasonability clause. It's about the fact that Bibi very insensitively said that God has not always protected us on European soil, which has taken a very strong place in the hearts of his ultra-Orthodox coalition partners. So it's not a match made in heaven, but they have enough in common to work together towards an extremist agenda. And that agenda involves authoritarianism. It's concentrating the power of the government, including greater control over the courts, just as Sharon said, over the media, the police, which have had a huge role in the last 8 months in Israel, significant structural changes going on there. Jewish supremacy agenda, which means specifically squashing the rights of anyone who is not Jewish, and also quashing dissent, whether it's from the media, civil society, protesters. And then, as I said, Jewish supremacy, which is being institutionalized through structural discrimination, and particularly the targets of that are the Arab society within Israel, but also asylum seekers and other foreigners. And the other enormous element, which I know is of the greatest concern to all of the Yachad supporters who are here with us today, which is the massive expansion of the settlement movement, takeover of the West Bank, and complete violation of any Palestinian rights. And in that context, the government came up with the judicial overhaul. So on January 4th, Yariv Levin, Minister of Justice, he got up and he made a press conference laying out a full plan for what he called phase 1 of the judicial overhaul. He announced plans to pass something called the override clause, review of basic laws, to abolish reasonableness, to change the makeup of the Judicial Appointments Committee, to limit the power of the legal advisors of the government ministries, the seniority rule for the Supreme Court, and more. And he did it in a very large, open way, which I have to say, maybe retrospectively, he might have done things different, but in some sense, he did us a favor, because people woke up and they said, what is going on here isn't just a new government with a slightly different agenda. This is a major plan to conduct a judicial coup. And by that, I mean to significantly change the system and to change the rules of the game so that they would have unbristled power. And so I want to say a few words about why they're going after the judicial system. So the judicial system and the judges themselves have come under attack in the last few years. There's been a lot of incitement and delegitimization of the court and the judges. And some of the specific issues include cases that I'm very proud to say that at ACRI we were leading, and in my previous job at the Hotline for Refugees, we were in partnership over the law of the anti-infiltration law, which went back and forth between the Knesset and the High Court between 2013 and 2016, a law based on putting asylum seekers in indefinite detention until they break down and leave the country. And the court ruled against it. It went back to the Knesset. The Knesset re-legislated it in an even more harsh version. It went back to the court. They struck it down again. It went back to the Knesset again, and it came back to the court. And then there was a less harsh version. And that ping pong back and forth, which I would say is the first time in the history of the state and the court that they cancelled the same law twice, became a symbol of the conflict between the government and the court, the Knesset and the government and the court, and was really used in a lot of a political way. It spoke deeply to the Likud base of fear around foreigners and the need to protect Israel as a Jewish country. Then there was Hok Hasdara, it's the expropriations law, 2020. It's one of a series of laws that has really gotten under the skin of the settler movement. It stopped them from being able to expand settlements. Specifically, that law would have allowed the government to retroactively legalize illegal outposts that were established on private Palestinian land. And that was as well a case of Acres together with partners Adala, and the court struck that law down as well. And that was one of them that has struck the settler movement's sensitivities, who I will say are really major force in the government today. When I said religious Zionism led Bezalel Smotrich and his partner Itamar Ben-Gvir, they are the rulers, and that for them the court personal because of agenda. And then the other major one that really bothers the court is conscription for ultra-Orthodox. As of right now, all the ultra-Orthodox young men are not forcibly conscripted to the army, also the women, but and the court has actually ruled against that in a judgment that has not ever been put into place. And so right now the ultra-Orthodox have a pass on the forcible recruitment, and they are in fear that the court will force them to go to the army and change their way of life. And so for them also, the court represents that threat. And as I said earlier, the merging of interests of those things have come together for them to attack the court. And also all of that, what I've mentioned, is particularly unique to Israel and to this government. What is not unique is the way that this government is going after the courts and judicial system. That is straight out of the playbook of 21st century authoritarian governments. And I want to quote to you from an essay from Kinlaine Chappell, American academic at Princeton, who wrote in 2018 about autocratic legalism. Buried within the general phenomena of democratic decline is a set of cases in which charismatic new leaders are elected by democratic publics and then use their electoral mandates to dismantle the constitutional systems they inherited. These leaders aim to consolidate power and to remain in office indefinitely, eventually eliminating the ability of democratic publics, their basic democratic rights to hold leaders accountable and to change the leaders' piece. And that is could be written today describing Israel 2023. So after the government came to power, they announced their judicial overhaul plan. The first one they went after was the Judicial Appointments Committee. They tried to bring it in March. The incredible protest movement, both in Israel, internationally, economic pressure, they put it aside and they decided to move on instead with the Reasonability Clause. The Reasonability Clause successfully passed on July 24th. And then immediately a bunch of organizations and independent lawyers submitted appeals on it, and ACRI as well, specifically about its impact on human rights. And the court and the case was cases were accepted, and a court date was set for today, September 12th. So what is the Reasonability Clause? The Reasonability Clause is a key tool that the judicial system has in order to conduct oversight on the government. It allows the court to disqualify a decision taken by an administrative authority, and that could be a minister, a government ministry, an institution, or a particular civil servant, or even a civil servant in a local authority. It is what's considered as the last line of defense between the citizen and the government against arbitrary or discriminatory power. And it's really critical for the protection of corruption, and it can be applied both to a government's actions or a government's inactions. I'm going to give you a few cases in which, examples in which the Reasonability Clause has been used by the courts. In 2007, a group of parents from Sderot took the government to court over the fact that their children's schools did not have adequate protection from the rockets that were coming across from Gaza. They followed an incident the previous year in which a rocket landed in the middle of a school, And the court ruled in favor of the parents that it was unreasonable not to fortify the school with proper bomb shelters and to protect the children from rockets. So that is one policy example. Another one is that it has stopped, they have used it to invalidate political appointments. So for example, earlier this year, Aria Dury, who is a convicted criminal, was meant to be appointed as the Minister of Interior, and based on the Reasonability Clause, the court intervened in that appointment. And so it's the tool that would be used if tomorrow Bibi decided to appoint Sarah, his wife, to be the head of one ministry, and his son to be the head of the next ministry, and his friend who has no professional experience to be the head of another ministry. It would be considered unreasonable, and the court would have the authority to intervene. So all the cases today ask to cancel the law, which cancelled the court's ability to use the Reasonability Clause. It is really, really significant because the first time the court is being asked to cancel a basic. You've probably heard the word basic law. Basic law thrown around a lot. Israel doesn't have a constitution. It has a series of basic laws, which is constitutional status. And it is the first time that the court is being asked to cancel a law. And that was a main part of what they discussed today in court, whether the court has that authority or not. And the seriousness of the case was reflected in the fact that from the beginning, they decided that this case will be heard by a 15-judge panel. That's the full panel of High Court justices. Never has there ever been a case where all 15 judges have been sitting there, and there was a lot of talk of how close they'll have to sit next to each other because they're not used to having them next to each other. And it was also really significant that today the Attorney General, whose job would normally be to represent or to represent the government in this case, has actually come out and provided her legal opinion, which is that in the case of most of the different arguments, she agrees with them. So the government had private representatives, not by the Attorney General, who was there today. And it sort of turned the whole thing into much more political process, which is of course very natural progression of what happens when you take something that is the judicial system and meant to be sort of independent legal and really try and politicize it all. And so, as I said, our case there was on behalf of 38 human rights organizations. It was really amazing to have really a diverse coalition of organizations that normally wouldn't be, have a lot in common, such as LGBT organizations and trans organizations, together with Arab rights organizations and Palestinian rights organizations, and it was a very big day. And I'm going to hand over to my colleague now, Attorney Hagar Shechter, who is going to share with you her insights of what we went there and what happened in court today.
Hi, thank you. Can you hear me? It's good. Stop. Can you hear me? Okay. Hi, thank you everybody for coming here today and for paying attention to what's going on in Israel. It's a very big day for us as Israelis and as ACRI in specific. So just to let you know, the court session is still ongoing. It's been more than 12 hours and it doesn't seem like it's going to an end. And our colleagues are texting us and sharing what's going on. To be short, so basically, today the Supreme Court was asked to decide two questions. The first one is whether they have the discretion to review constitutional amendment. I'm sorry that I'm slow. It's been a long day. And the other question is, even if they have the discretion to do so, is this the case that they should intervene in a constitutional amendment? It was a very, very, they ran a very interesting and passionate discussion. And it looked like an hour ago when they took a break, it looked like that they had enough. It was politically charged, but it mostly that the atmosphere was politically charged, and the arguments were legal arguments. Interestingly enough, Rothman, who is he's a Knesset member from the Tzionut Datit, and he represents a very, very right-wing view. He's the head of the Committee for Constitutional Amendments at the Knesset. He represented himself at court today, and he didn't litigate. He made a speech, actually a very extremist and scary speech. He was almost threatening the judges. Also in his court arguments, in the written arguments that he submitted, some of the judges stopped him and told him that the way that he treats them is disrespectful. He called them oligarchs that took over the country, and that they are just like Napoleon. And he's the person who he's the architect of the law. But at the end of the day, I really don't know where we're heading. It's difficult to summarize. The judges asked a lot of questions, and some of them gave their position away, and those that did, it was in line in what we've expected. It looks like most of the judges think that they do have the discretion to review constitutional amendments, but I cannot say that they are convinced that this is the case to intervene. It's difficult to say. I mean, we're doing this webinar while the case is still ongoing. It might be easier to summarize tomorrow or next week. I don't know.
Thank you very much to both of you. I think it's very helpful to get kind of the overview and your views on what happened today, Hagar. I was also watching the video kind of in the background as the legal nerd that I am throughout the day, and it was very depressing to say the least. And I think you hit the nail on the head in terms of Rothman's populist speech rather than a legal argument. In terms of the questions, just a quick question from someone who asked their question anonymously is, do the judges presumably need to decide on this matter unanimously, or should there be a majority decision?
A majority decision.
Thank you. And we have a question from Ido, who also mentioned the flow chart about possible consequences that he saw in Haaretz, and feels that, he expressed that he feels that the situation is very bleak, and asks both of you what you think and whether there is a light at the end of the tunnel. So it might maybe be nice to hear a little bit about what kind of bigger picture consequences we can expect, given that, as you say, Hagar, the judges didn't say anything that was particularly surprising given their kind of predispositions before. And maybe, Tamara, that's also a question for you as well.
Mark or Sharon, do you want to take this one, or should I answer it?
Sure, I'm happy to say a few things. So in terms of where to from here, I think one of, as I mentioned, the big things that they talked about today was, are the judges looking at just this specific amendment, or are they looking at the bigger picture? And I don't know what the court will answer that, but I will say that most of Israel and Israeli society are now looking at that bigger picture. And we kind of joke in the office here that if someone told us 8 months ago, hundreds of thousands of people will come to the street based on the reasonability clause, it's laughable, because who even knew what the reasonability clause was? And the truth is that if you went yesterday to the protest that was outside the High Court with tens of thousands of people, what is the reasonability clause? I'm sure that a hell of a lot of them wouldn't know how to answer you, but they understand what this is about. It's not about the reasonability clause, it's about trying to fundamentally change the system and consolidate power. And that is an amazing thing. It is really a political awakening that we didn't expect. Having said that though, there's also, I guess the main narrative around that is that we need to save the High Court because they are the protector of human rights. And as my colleague Gil, who stood in court today, said, we are not here as the Association for Civil Rights to say that this High Court of Justice is the beacon of human rights in this country. It has many, many, many times disappointed us. It has allowed the violation of some of the most vulnerable people's rights over and over again, and particularly when we talk about Palestinians in the occupied territories, the 56 years of occupation that it has been complicit in. And for it's an interesting moment. It's for us to say this is a wonderful, welcome development, whilst at the same time us knowing that our role here is going to continue to take this political awakening direction, and that democracy isn't just about democracy for Jews. It has to be about democracy and human rights for everyone who lives here and who lives under Israeli rule. Certainly the political awakening gives us a lot of hope that there is, that things can be different.
Thank you, Tamara. Before I kind of hand over to Sharon to maybe tell us a little bit more about this political awakening, I'd like to just hone in a little bit on what you were saying about the reasonability clause, because I think that that's an argument that, first of all, came up quite a few times today in court, where many people were saying, representing the government and saying, look, the reasonability clause has only been used just over a dozen times and in the past few years and so on. It's not really such a big deal. It's not as dramatic as all of you are saying it is, and that's an argument that I've heard within the British Jewish community as well about this particular hearing. So can you tell us a little bit more about why you think the reasonability clause is important and how it fits into the wider picture of the judicial overhaul in coming days, and whether you think the judges might buy into that argument? Because I know that your petition also mentions this kind of salami approach to the judicial overhaul. So if you could expand a little bit on that.
I just want to interfere and say that I think it was 22 times that it was revoked by the Supreme Court since Israel was established. That's the number.
Thank you. Thanks.
So I mean, there are a few ways to look at your question. And I think we should start, and maybe the British Jewish community shouldn't think about reasonability the way that the British courts think about it, because in Israel we don't have a constitution, we don't have a Bill of Rights, and the way that our political and system works is that the government rules the Knesset. The same people in the government are in the Knesset, so the parliament's ability to overlook the government's actions is very, very weak. The almost only measurement that Israelis have to block the government's power and civil servants' power is administrative administrative petitions against their decisions. And one of the best ways to do so is to attack the reasonableness of the decision, because the threshold that you need to show is not as high as other machines, as other legal measurements that we have, such as discrimination, that you need to prove an intention to discriminate, or other tools. So first of all, we're not talking about a country where we have other ways to limit the government's power. And the way that the government, the way that this law is doing it is not under a big structural law that is trying to revise administrative law, but only by taking the court's ability to review the reasonability of the government's actions. So it basically means that the government has to act in a reasonable way, but if their actions are unreasonable, there's no way to force them or to enforce this to enforce it on them. It's basically the same as saying that you have a law that says that you cannot drive on 200 miles per hour near schools, but if you do so, nothing will happen. So we have nowhere, if this law will pass, we have nowhere to take it. And all people that are saying that it's nothing, some of the judges say, well, if you will not use, you can say that instead of unreasonable, you can say it's inconceivable, but it's not a semantic argument. You're not changing you're not amending the Constitution just to change wording and phrasing. They're saying that they are above the law. And it's a severe thing, especially in a country where this is our only way to limit their actions.
Thank you, Hagar. Yeah, I thought it was actually quite funny to see during the hearing today that there was a little quip that one of the judges said in the middle of it, just asking Rothman, where would you want us to carry out judicial review at Strasbourg? Because, obviously referring to countries that can refer to the European Court of Human Rights. And Rothman said, no, in the Knesset, right? So he wants the Knesset to be kind of at the top and have the final say on any political decision.
The only say.
Sorry, the only say.
But no, he's not saying that the Knesset should do it. They continuously said that the government should have the last word, and the government is the government should get its power from the Knesset, and this power should be limited. They want to have an unlimited power. When he was asked what will happen if the Knesset will legislate undemocratic laws, even more undemocratic laws, he said you don't have the discretion to overview it.
Yeah, thank you. I think maybe to answer some of the questions, because I see that we're getting more and more questions in the chat. Pamela asked whether the press is on our side in terms of the government ignoring democracy. And I'm wondering, Sean, if maybe you would like to tell us a little bit more about the kind of public discussion around the reasonability clause and, what Tamara was referring to earlier in terms of this being a moment of public conversation around the role of the judiciary and this issue in particular.
I just want to say one thing about the previous question about, is there hope at the end of the tunnel? I think we're moving between moments of despair to moments of hope. And on the one hand, there's this incredible government, in the coarse sense of the word, the most extremist, the most radical, the most fundamental, the most outrageous bunch of religious zealots and messianic nuts that this country has ever encountered, criminals who were given the right to rule and are now kind of running free and doing as they wish. And the other thing, so this is the despair part, but the hope comes from the movement and this awakening that Tamara mentioned. So if we lose the hope, we're basically handing over on a silver plate what they want and the ability for them to execute their agenda. So we have to hold on to the hope at all costs, and we have to keep on the fight. And that's what we're all doing. And that's why the protests are happening and all the other activities. As for the press, so keep up the hope, everyone. It's a very important thing to hold on to. Is the press on our side? The Israeli press is, the majority of the Israeli press, I would say, is on the right side because they have common sense and logic and the ability to deduct that this is all anti-democratic, and they are under the same attack that the new legislation that's being put forward and proposed will affect the media as well. There are lots of laws to curb media's independence, to take over. There have already been measures against the independence of media channels, particular Yachad and particular others, Israeli media establishments that are being under Netanyahu's fire. On the other hand, there are channels that are funded and supported by the right-wing coalition, like Channel 14 in Israel, and they basically act as the government's propaganda distributors. And we have the same outside of Israel, but I'm talking only about the press in Israel at the moment. My sense is that they are generally on our side. They're not, they remain sort of objective, but also I would say that there's the mainstream Israeli mindset. And the mainstream Israeli media has always been in the service of that mindset. So things have changed now that the government is extremely radical, but it's important to put it in the greater context of reporting on what happens within Israel and outside of the green light borders. And it's an ongoing discussion whether the media in Israel is recruited and to whose side.
Thank you, Sharon. We have a few very kind of legal questions and also about the structures of the legal system in Israel. And Pamela is asking, how similar is the reasonability clause to judicial review in the UK in terms of challenging administrative and government decisions? And I appreciate that you might not be kind of experts in UK law, but I know that there was a lot of discussion about kind of comparative law in the High Court today, especially in terms of countries such as the UK and Australia expanding their judicial review processes while Israel is now limiting its own. So Tamara and Hagar, if you'd like to comment on that.
Hagar, that one's with you.
Comment about how is the Israeli, I'm sorry, I was with you, but also watching the discussion, to comment about how is the Israeli legal system is similar to the British one?
Yeah, in particular, the reasonability clause and just processes of judicial review.
I'm sorry, I'm not big on the British on the British legal system. I can say that in Israel it's broader, from what I understand. But other than that, I'm not an expert. I know more about American and Israeli legal systems. I can explain the Israeli one and you can explain the British one if you want to.
Thank you. Sadly, I have a background in international law, but I'm not a lawyer myself. Although, you know, as mentioned earlier, right, there is, because of the European Convention on Human Rights and the UK in 1998 having its own Human Rights Act, there is an option for the courts to issue what's known as a declaration of incompatibility if British laws are not compatible with human rights law of the EU. And again, these kinds of protections do not exist in Israel. That isn't part of such a wider kind of regional human rights court.
Also, I think that Israel is special in a way that some countries has a constitution and some countries doesn't have a constitution, but no country has a constitution that is written over more than 75 years. And the government and the Knesset are saying that the court doesn't have the authority to overview the basic laws because the constitution is not, the writing of the constitution is not done, and they're using it against it. I mean, it's an argument that they're using in order to legislate unconstitutional basic laws. So whenever we're trying to see how other countries' constitutional law operates, it's difficult because we're the only quasi-democracy that has a constitution but doesn't have a constitution.
Yeah, thanks, Agar. Yeah, and I think, in the case of the UK, right, the constitution here is also uncodified, but it is a kind of we do have a bicameral parliament in the sense that we also have the House of Lords to offer additional review where needed.
Right.
And a long history of common law, right, that, as you mentioned, Israel doesn't have. I think we're reaching kind of the end of our time here, but before we reach kind of closing words, I'd like to combine two of the questions that we've received. So Barbara Winston asked whether the judges may make a decision that nullifies their own role. And I think there was some interesting discussion around, Rothman accusing the judges of being self-interested in many ways and wanting to preserve their power, as you mentioned, being a sort of elite. And then other people, talking about the need of the court to maintain its power. And finally, we have another question from Pamela about whether there will be compliance by the government if the ruling is against them. So if maybe we can go from Hagar and then Tamara to kind of answer this question and add some final words, and then I'll pass on to Sharon and close the webinar today.
As for the second question, I'm no politician. I don't know. Yes, the Supreme Court can rule against their prior rulings, and it happened before, it also happened in the US just recently, but prior rulings were given by almost the same judges that are operating now, or at least some of them. And I don't think that Chayut and Fogelman, some of the more, I'm sorry, I don't think that they will change their minds. What they can do is rule that it's not the time to rule, that the case is not ripe enough, that all sides can save their arguments, and that if indeed it will look like that this amendment is unconstitutional, the petitioners can petition again. And then they will not have to give a decision at all. And it looks like at least some of the judges are heading this way.
Thank you, Agar. Tamara?
Sure. I mean, the questioner obviously pointed out the very sort of self-reflexive nature of all of this, which is that the judiciary and the judges, they get to rule on their own power. They're the ones who are deciding about, and it's complicated and sensitive, and there are those like Rothman who argued, well, you can't even rule on it because how can you be objective? But the reason why they rule on it is exactly because it is so important that it shouldn't fall all of it to elected officials who these days are working very, very popular tactic. So in terms of where to, officially the court does time in which they have Hayut, who is the president of the court, is retiring in the middle of next month. Another 3 months on which she can find judgments. That brings us to January 16th. But they will make something sooner. There is many cases that are pending and waiting for this kind of answer. And then obviously there's the question of what happens after. Let's say that the court does strike down the law and it says that cancelling the reasonableness clause should be cancelled. What happens then? And the reason why there is this big question of what happens is because there are so many members of Knesset from the extreme right wing who have already come out and said that they will not obey the ruling. And it's really, really unprecedented in Israel. We also are not really sure where to look on what this is. It would be a scenario of a constitutional crisis if they ignore the court's ruling. They are certainly laying the groundwork for it. The amount of incitement against the court, against the judges, the amount of tweets saying that they have no authority, they shouldn't be able to decide. Tali Gottlieb, there was yelling from the bench, not the bench, from the audience in the court today, and saying, really just vilifying them until it's really laying the groundwork to undermine them. Bibi for himself has been asked this in the media a lot. Will you abide by the court ruling? He was not willing to say that he would. He also definitely hasn't stated that he wasn't. I will say that it's expected that if they ignore, it's a form of chaos, it's a constitutional crisis. It will have a huge impact on the Israeli.
Tamara, I think you're cutting out a little bit. Maybe we can bring you in a little bit later. If we can pass over to Sharon for very, very brief kind of final comments. I know that people have also asked about the involvement of Orthodox communities in the UK in protests. And maybe if you can tell our audience a little bit more about how they can get involved and defend Israeli democracy UK.
Yes, I want to quickly answer two questions that were raised. If the government is successful with its proposed legislation, can the changes be reversed in the next election? So no. If this government goes ahead and the next point in time where we revisit the legislation is in the next elections, there would have been too much damage done. It will not be reversible because these laws that are being implemented will allow processes that are so overarching, the politicization of the civil service, the implementation of various laws and norms that will be underlying so many different aspects of Israeli society, culture, media, individual rights, women's rights, so many different aspects of life in Israel that it would not, even if the laws are reversed back to where they are now, things would be different by that point. It would not be possible at that point to fire individuals who have been put into position by this government or rehire other individuals in senior positions like the Attorney General who have been made redundant. So it would be catastrophic to allow this government to run the course of its. But luckily, the shelf life of a government in Israel, of any government, is typically 15 months. So we're hoping that the shelf life of this government will be even shorter, obviously. The Orthodox communal organization in the UK, are they standing up to be counted? There is an ongoing discussion with these communities. We have the support of the liberal, reform, Masorti side of the community. We've had that all along, and they're becoming more and more vocal. More recently, the Board of Deputies and the JLC have also came forward with statements and two articles recently in support of the protest movement, which is a very positive sign that the community is feeling more comfortable in expressing clearly its support, but the Orthodox segments of the community are still finding it difficult. Even those that are behind closed doors supportive, they're still not comfortable enough to come out and either join us in protests or express more their criticism more publicly. To say a few words about Defend Israeli Democracy UK.
We can just keep it short because we're running out of time.
Short.
I think people are...
If you can put our links to our channels, stuff in the chat that people can follow the updates and the information. We do various activities, we run various activities. The protests are a part of it. This is the expression of other work that's being done behind the scenes. But most importantly, I would just ask everyone on the call to stay informed, engaged. It's very, very important that you communicate the fact that this is urgent. There's urgency here, and there's not much time for debate whether we should criticize or we shouldn't criticize. I think for a Yachad crowd, I probably shouldn't be saying that, but generally, the more engaged the public in Israel and outside of Israel is, and the more it's critical and the more you join us in our activities, the higher the likelihood that we can avoid the crisis that this government has confronted us with. Thanks, everyone.
Thank you. Thanks very much, Sharon. I have sent the links to all the Defend Israeli Democracy groups in the group chat, and we'll also add it to the Facebook. Before we leave, I'd just like to also share our link tree with links to all of our social media, and share the fact that Abir Jubran, who is the former director of the Human Rights in the Occupied Territories unit of ACRI, and who is now an attorney for the Arab Minority Rights Department at ACRI, is going to be joining us in the first week of November, and we're going to be bringing her to synagogues cross-denominationally and to meet her with communal leaders and with parliamentarians. And so if you want to stay up to date with her visit and with our upcoming webinars, please follow us on social media as well. I see that Tamara has one final comment to add before we finish for today.
Hi, can you hear me?
Yeah.
Okay, sorry, I don't know my computer. I'd like that. I've come over here to Hagar. I have to share this last quote with you, and I think it's perfect to end on. It follows on everything that Sharon said and that you just said stuff. And it's from the American academic that I quoted before, and she says, "New autocrats have learned that they can consolidate their power if they simply get their opponents to give up and go away, or to stay home and mind their own business. They don't need to imprison or kill those who object to autocracy. They simply need to get them to tolerate the diminished freedoms on offer." So therefore, my final thing to say to you is do not give up, do not go away, do not stay home, and in true Israeli style, do not mind your own business.
Thank you very much, Hagar, and thank you. Oh, sorry, so Tamara. I was just reading off the. It was really wonderful to have you join us here today. I will say that if people want to take direct action beyond coming to events like this, you can join the Defend Israeli Democracy group chat. We also have a campaign going on at the moment to send letters to James Cleverly, the Foreign Secretary, who is currently on a visit to Israel, Palestine, and asking him to stand up for democracy. And so if you want to get involved in that in a very specific way where we as British Jews can influence the foreign policy of our government, then that's a great way of doing that. Thank you so much for joining us tonight, both on Zoom and on Facebook. And thank you, Hagar and Tamara, for joining us after what I know was a very long day and many weeks of preparation to the High Court ruling today. And thanks again, Sharon, for co-hosting this with us with the full Defend Israeli Democracy group. Thanks, everyone. Hope you have a good evening. Thank you.